This program is brought to you by Emory University.
Hello, everybody. Thank you for coming. We're going to get started here. First, I'd like to give a special thanks to Sapna. Where are you? Here she is. Thank you. If it wasn't for Sapna, we couldn't have done this event. Also, I'd like to give a special thanks to Emory's Corporate and Business Law Society. They are sponsoring this event along with the journal. Thank you very much. So, I'm going to introduce Mr. William Hicks. He is the Regional Director of the SEC's Enforcement Division here in Atlanta. And I'll bring you through some of his history. So he grew up in Long Island. Oh, okay. Senior, let me correct his job title. Senior Trial Counsel here in Atlanta. And so Mr. Hicks grew up in Long Island, but he went and did his bachelor degree in Dickinson College in Pennsylvania, and that was in 1975. And shortly after that, he did his Juris Doctorate degree in Brooklyn, New York, and he graduated in 1978. After that, he worked in New York after graduating with the New York State Controller, which runs the New York State Employee Retirement System. And he did that for about 3 years, from 1979 to 1982. And then, around 1984, he went to Miami, and he joined the SEC's Miami Regional Office. And he was an enforcement staff attorney. So the SEC has multiple divisions, and Mr. Hicks will tell us all about that today. And in 1986, he was promoted to the branch of the SEC in Miami. He was promoted to the branch chief. And then, in 1989, he was promoted to the assistant director of Miami. And in 1992, that's when he made his way up here to Atlanta, and he joined the Atlanta division as a regional trial counsel. And in 2010, he was promoted once again to his current position now. So his main responsibility is, as a member of the SEC, is he serves as the to enforce those who violate the nation's security laws and hold those accountable. And so that's what he's going to tell us about today, some of his job and his experiences. He has over 25 years of experience. So could you all join me welcoming Mr. Hicks?
Thank you. It's very nice to be here. I guess in all my years of experience, I didn't know how to make my PowerPoint work, so I'm going to go without it. But needless to say, I have to, if you've ever heard people from the SEC speak before, we always start off with a disclaimer. And basically, everything that I'm going to say today is my own view and does not reflect, the official views of the SEC or anyone else at the SEC. So, with that disclaimer, I want to first go through just a general overview of the agency, and then talk a little bit about some of the types of cases we do and things like that. And then hopefully we can have a Q&A, and you can ask me, what interests you, and maybe I can enlighten you about stuff. The SEC itself, as you may or may not know, is 5 commissioners appointed by the president for 5-year terms, no more than 3 from the same political party. Now, when I say 5, it's up to 5. Sometimes there's vacancies. I think right now we have 3, but 5 is the concept. The SEC is divided into main operating divisions and offices, and there's a number of them. I would say the biggest are the following: enforcement, which is the section that I work for, which does, as its name indicates, enforces the law. The Division of Corporation Finance, which is a division which intakes annual reports and quarterly reports and things like that from public companies and establishes rules and go-bys for them. The Division of Investment Management, which is responsible for oversight of the investment management business, which I'll talk a little bit more about, but which is investment advisors, mutual funds, hedge funds, things like that. In other words, entities that manage other people's money. The Division of Trading and Markets, which when I started was called Market Regulation, but now it's Trading and Markets, which oversees exchanges and brokerage firms and things like that. The Office of Compliance Inspections and Examinations, which we sometimes call the National Exam Program, which is a large group of examiners who function like you might think of bank examiners, except they're broker-dealer examiners or investment advisor examiners. And they go into the entities that we actually regulate, which are brokers, investment advisors, exchanges, things like that, funds, and they conduct examinations to make sure that they're complying with all the procedures they're supposed to comply with and to look for potential problems. The Office of Chief Accountant is another one, and that oversees to some extent the accounting industry but stays on top of accounting developments and accounting cases. The SEC is divided into, we have a headquarters office, which obviously is the biggest and has a lot of those divisions in it. And then we have regional offices in, I think, Atlanta, Boston, Chicago, Denver, Fort Worth, LA, Miami, New York, Philly, Salt Lake, and San Francisco. And the regional offices, like Atlanta, are basically enforcement and the exam program. The other divisions of the agency are in Washington. So, if at some point you want to work for the SEC and you think about what you want to do, it will matter to some extent where you're willing to live. In other words, if you want to work in enforcement, you can work in any of the regions or the home office, but if you want to be a corporation finance expert or in one of the other substantive groups, that's in DC. The agency regulates a large population of regulated entities. The numbers I have, and these are probably from a year ago, 4,500 registered broker-dealers, which have 629,000 registered representatives, 10,500 mutual funds and ETFs, which as of the date of these numbers had $15.6 trillion in them, approximately 12,000 investment advisors with assets under management of about $62 trillion, and not regulated by us, but reporting through us are about 9,000 public, what we think of as public companies. And we don't, in the broader sense, regulate public companies as public companies, but we regulate the reporting process. Now, in addition to that, we have a broad-based responsibility to enforce securities laws. The primary statutes that we operate through are the Securities Act of 1933, which people call the Securities Act, which deals with offerings of securities, public offerings, things like that. The Securities Exchange Act of 1934, which deals with the purchase and sale of securities and trading and things like that, exchanges. That's where Section 10B and Rule 10b-5 that you hear about are. The Investment Advisors Act of 1940, which, as you might guess, deals with the regulation of investment advisors. The Investment Company Act of 1940, which regulates mutual funds. Investment company is pretty much the technical term for a mutual fund. And something called the Foreign Corrupt Practices Act of 1977, which deals with largely, bribing, as we use it, bribing foreign officials by by American companies. The Enforcement Division in particular takes legal action regarding cases that impact on any of those statutes. And an important point, can sue anybody who violates any of those statutes. So the enforcement responsibility is broader than the regulatory responsibility. We can sue people who we do not regulate as their regulator, in other words. Now, what can we do when we bring these cases? In enforcement, which is what the lawyers do in enforcement, we have two forums that we can operate under. One is we can bring civil actions in district court, and those are, the core of the action is usually an injunction action to enjoin violations. But over the years, many other authorities have been added to that. We can get disgorgement of ill-gotten gains from wrongdoers, which is essentially the profit that they have. We can get civil penalties, which is a fine, and there's statutory parameters for that. We can bar people from being, we have to ask the court, obviously, in a civil action, but bar people from being officers or directors of public companies, being involved in penny stock offerings, dealing with municipal securities, all kinds of things like that. And we can also get other relief like, accountings and where people have to account for what they did with the money. In emergency cases, we can get temporary restraining orders. We can freeze the assets of the wrongdoers. We can put receivers in to take over businesses, all those kind of things. And the process as it works, which I'll come back to, is actually much quicker for that than it is for the standard case. The other forums that we have are administrative proceedings, which are before administrative law judges that work for the commission. And there's a couple kinds of those. One is a straight administrative proceeding for regulated people. In other words, if you're in the brokerage industry, or you are the entity, or you're an investment advisor, or you're associated with a mutual fund, the entities that we actually regulate, we can get similar relief. We can get cease and desist orders. We can bar them from the business. We can revoke the registrations of the entities, and we can get disgorgement and civil penalties and those type of things. And then we can have cease and desist proceedings, which again we can bring against anybody who violates, which are somewhat parallel to what we can get in district court with the relief, except for the receivers and things like that. But so we have a wide variety, and we look at different things in bringing those cases. There's obviously much more extensive discovery if we bring a civil action than if we bring an administrative proceeding, although we've added some recently. And usually if you bring a civil action, what happens is you have years of discovery and maneuvering, and then you have a trial 2 or 3 years down the road, and you get your relief right then. If you bring an administrative proceeding, you go to court, you get your trial much quicker, and then you have years of appeals after that. So it's there's different issues that go into either one, but that's the general format of it. And the way it works, the types of cases that we tend to do, and there's an endless litany. And one of the things for me that's been fascinating is that the securities laws, there's just a vast amount of law. And no matter how many years you're there, you're always coming onto something that you haven't seen before and something new. The schemers come up with a lot of, there's a new fraud scheme that someone thinks of, a new way to break the law all the time, and they tend to be complicated and interesting. But, just for example, we do insider trading cases, which, you probably know what that is. People get inside information and trade on it. We do a lot of those. We do market manipulation cases where people engage in trading practices to manipulate a stock price to, like go up and then they dump their stock. We do a lot of financial fraud and accounting misconduct cases. I happen to think, for example, if you have an accounting background and a law degree, that's a good thing to have in this area. But there's a lot of different types of accounting fraud, offering frauds, Ponzi schemes, prime bank schemes. There's an infinite variety of scams that I guess we could call offering frauds, from straight out lying about what your company has, what your company's going to do, what your company's going to do with the money, to the prospects for your company's products, etc. Ponzi schemes, you probably know what a Ponzi scheme is. You offer everyone, you invest $1, you get $2 back, and that money comes from the next people, and it just becomes a bigger and bigger pyramid till it collapses. And some of those are actually more interesting than that, because most of the ones we see today are tied into a business. In other words, you have a real business, but it promises a return that comes from the fact that it's constantly bringing in new investors, and that's where the extra money comes from. I did a case maybe 10 years ago called ETS payphones, and you probably saw they used to be in the airport. They actually had like 25,000 payphones, and they had a big facility, and they had videos where they were dumping all the quarters into this machine that counted them, and et cetera. But what they were doing was, and I'll come back to the definitions later, but they'd sell phones to people, and then they'd lease back the phones, and then they would place them and manage them, et cetera. And they promised people like 14% guaranteed safe. You own the phone. You can't lose your money. You own the phone. But they'd put like 4 or 5 phones in the back of some store where no one ever goes, and there just aren't that many locations. So how did they pay that 14% return? They recruited more and more and more investors. And that was a good example of how you really see the pain, because I think they focused a lot on elderly people, and they really sold that return. As you may or may not know, I'm coming to grips with now, but a lot of elderly people, the return they get on their whatever they've saved up in their life is directly relevant to their lifestyle. So, if interest rates go down, it can become tight. So someone comes along and here's 14% a year, safe, can't lose the phone, sounds good. And they took a lot of people and did a lot of damage. And that was a very interesting case, because we shut them down. We put in a receiver. The district court was very supportive. The 11th Circuit actually reversed and said it wasn't a security. And that, I'll come to the technical definition later, but because it was a fixed rate of return, right? So we took it up to the Supreme Court, and when we get up there, the Solicitor General actually argued the case. At the time, it was a guy named Ted Olson, and we prepped him, and the court ended up ruling for us 9-0 on the point. I think we had the law right. But Justice O'Connor wrote the decision, and she started off her decision with a line, something along the lines of, from a TV commercial, opportunity knocks or rings, and then she said, and sometimes it hangs up, and then she went into the whole case. But it was a Ponzi scheme, and at the end there was a big hole, because they owed all these people all this money that they had used to pay returns to other people. But that's a Ponzi scheme. We have prime bank schemes, which never seem to go away, and those are exorbitant schemes that promise exorbitant returns, with the money allegedly coming from the trading by prime banks in these secret financial instruments that the top banks of the world use to trade between each other. And the whole thing is made up. There is no such thing, but schemes just don't go away. So those are offering frauds. We're looking at a lot of cases with structured products, derivatives, complex financial instruments that are either put together in a way that's fraudulent, or that are misvalued, or that are sold to people for whom they're not suitable. Our office did a big case against Morgan Keegan a few years ago because in a lot of their funds they were misvaluing RMBS. RMBS are pools of mortgage-based securities, essentially, and they were illiquid, and they were using arbitrary methods to price them. But that's something we do. Asset management, we do a lot of cases in that space, and those are investment advisors and funds and hedge funds, and they do all fraudulent things also, charge excess fees, misrepresent their returns, et cetera. Obviously, investment advisors could do a wide variety of fraud, but we look at that. Municipal securities is an area that we are becoming more and more active in, and that's actually a huge market dollar-wise, and there's a variety of fraudulent conduct that goes on there. The FCPA stuff, you periodically hear we do uncover cases where companies are bribing foreign officials, and we take action about that. The way we get our cases, we have a number of ways. One is our exam program, and I looked at a pie chart not too long ago. At least for our office, I think it's the biggest single source of cases that we've brought, I believe, is our exam program. But it doesn't dominate, it's just a big slice. We get a lot of cases from our internal, what we call our TCR system, which is tips, complaints, and referrals. And we get them in directly here, and we have a centralized system in DC that gets them and parses them out. For those, there's a lot of them, and we have to pick and choose what we're going to work on. But there's a constant, as you might imagine, in our space, a constant flood of complaints, and my broker cheated me, and this, that, and the other. So we get a lot from there. We do a lot of work with referrals from other agencies. In addition to the SEC, there's kind of a comprehensive system of regulators. Each state has a state regulator, state securities regulator. Some are bigger than others, but they're all out there. There's FINRA. I don't know if you've heard about FINRA. It's the Financial Industry Regulatory Authority. They regulate brokers, and they provide a lot of information. And the criminal authorities send us stuff, and we work with them a lot. The FBI, U.S. Attorney, things like that. And sometimes if we have a case that is severe conduct, we will wire them in, and we will work jointly, or we will work separately in some cases. But as you know, people do get prosecuted for insider trading, and that's where that comes from. Sometimes we get complaints from competitors. It's not a nice world, but if your competitor is offering a deal that's too good to be true, it hurts you. So people sometimes will pick up the phone. Investor complaints, and sometimes from the news media. So it comes in from many ways. And again, our jurisdiction, any violation by a regulated entity, and there's a lot of, in addition to fraud, there's a lot of compliance rules and things like that, or any violation really by anyone. We can bring enforcement, but some of the rules only apply to regulated entities. Then we go through, is it a security? Because any of our fraud cases, we have to look at, is this actually a security? There are statutory definitions, stock, bond, interest in a profit-sharing agreement, option in a security, or the big one is investment contract. Investment contract is where we bring in these strange investment schemes like the one I talked to you about. And that is essentially based on something we call the Howey test. And this is from a case in the 1940s, a Supreme Court case, SEC v. Howey, which involves, came up with the definition of investment contract, which includes an investment of money, and it can be a thing of value, not just cash. It's evolved over time, in a common enterprise. And there are different definitions of that. It can be pooling of money between investors. Some circuits, it can be a commonality of interest between the investor and the promoter, et cetera. But one way or the other, you're putting your money in either with someone or in a shared purpose with someone. And then an expectation of profits solely from the efforts of others. solely has evolved away from solely to mean the essential managerial efforts. And usually it means the promoter's going to do the work to affect the profits. The Howey case itself, it was an owner of an orange grove that sold fractions of the real property and promised to grow, market, and sell the oranges and pay profits back to the people. The payphone distributor was going to sell the phones and then install and service them. The profits were contractually guaranteed, but that was still found to be enough. Sale of pooled life insurance policies, viaticals can be. We brought a case recently at Credit Nation where they were buying viatical life insurance policies, but they were running the business. And I think the essential point is, if they're pooling money and they're going to run it and they're investing it in anything, it's probably a security. And I've had cases that, art, an art fund, that's a security. The art's not a security, but the fund is, the interest in the fund is the security. And that's essentially the theme. There's infinite variations on that. Real estate, just anything literally. I think there was a case with a wine fund. People would say wine's not a security. No, it's the fund. It doesn't matter what you're investing in. We brought a case in Charleston a few years ago against a guy named Al Parrish. I don't know if anyone here is from Charleston. But he was a prominent, he was an economics professor at one of the local colleges, and I think he had a TV show, and he called himself Econo Man, and he made economic predictions and those kind of things, and he had a bunch of funds. He drove around in a car with a polka-dotted roof on it, and our examiners went in there, and one of the things we do is we check assets. And he had all these funds, and he gave statements that, here's an account at this broker where we have $40 million, and here's an account over here. And it wasn't a hard case to make. They took the statement, went to the broker, how much is in the account, and it was like $4 million instead of $40 million, and the whole thing kind of blew up. But he ended up going to prison for a long time. But those kind of cases, and those are good cases, and they make a lot of difference. We do a lot of compliance cases also, and there are very complicated rules and regulations that deal with the brokerage industry, the exchanges, mutual funds. You don't think about it, but everything in there is controlled, so it is protected, and so it the value is effective. Honestly reflected for investors and things like that, and our compliance people or exam people find problems, and sometimes we bring cases on those things. As I've said, we work heavily with Department of Justice and other agencies. We are allowed to do that. We are allowed to share information and do investigations as long as we have a legitimate purpose ourselves, and we're not just, doing the work of the other agency. And, I think we try to have a comprehensive enforcement program in the sense we've got state regulators, we've got self-regulatory organizations, we've got the SEC, and we've got law enforcement. And between all that, we try to really have a complicated and a comprehensive approach to investor protection. So that's kind of the overall. I can tell you a little bit. Let me tell you a little bit about how enforcement works internally, because I think that's kind of interesting also. A case starts, we get a tip or a complaint or a referral. We decide to open something. We open something that's called a matter under investigation most of the time, or a MUI. It's sometimes referred to as an informal investigation. That nomenclature is a little misleading because it can have the same consequences as a formal investigation. But we'll start looking at it. If it looks like we're going to need subpoena power or something along those lines, we convert it to what we call a formal investigation. And once we do that, the staff can issue subpoenas to people. So investigatory attorneys have subpoena power once they're authorized. And then we conduct very wide-ranging investigations. Sometimes they're quick to the point. Sometimes they go on for years and involve millions of documents. And that's something that you deal with in our line of work. You can sometimes get millions of documents in a case, and we have search machines and all that stuff to help sort through them. But there can be a lot of paper. It's not usually paper anymore. It's usually digital, but a lot of paper. The staff goes through, takes testimony, does whatever analysis they have to do. At the end, if they decide that there's a case, they bring it to management. It's vetted. If there's a tentative decision locally to go ahead with the case, for example, normally the people on the other side are entitled to do or allowed to do, it's a privilege, something we call well submission, which is the staff will reach out to them and say, we are considering recommending charges. You can do a well submission, and normally we'll go through with them what the charges are, what the evidence is, stuff like that, and then they can write a letter to the commission arguing, please don't sue us, here's why. When I say letter, 40 pages or something, I mean, it's essentially a chance to make their case. The staff, assuming it goes ahead with the case, will prepare something called an action memo. And in the SEC, that's kind of the document that controls the process. It's a recommendation memo to the commission that lists all the facts and the law and why these people should be sued. It's reviewed up and down internally in the office. It goes to Washington. It's circulated to a bunch of those divisions I mentioned earlier, any of them that actually have an interest in the subject matter of the case. We have a general counsel's office that reviews it. We have an enforcement chief counsel's office. It's probably 20 people get it. They comment on it. We make whatever changes need to be made, and then it's sent to the commission. The commissioners vote on it. It's a closed meeting, closed to the public, open to commission staff, and they vote on it and have discussions. And it's actually authorized in a vote every case we bring by the commission. Then if we file, it goes back to the region. The litigators take it and they litigate the case as needed. And if we settle, that gets approved by the commission. So it's a controlled process, and the staff has to get authority for a lot of things. So there's a lot of writing involved, for what it's worth. So that's pretty much the picture of what we do. I don't know, does anyone have any particular questions or things they would like to ask? Sir.
So I have a question regarding FCPA.
Mm-hmm.
Basically two questions. It's about a hypothetical. Suppose a company, U.S. company, goes overseas, and one of the government officials says that I'll grant you the contract, but I'll grant you the contract. I mean, take the approval, but you'll get it after 5 years. Now, if you want to expedite that, you pay me $1 million. So you're basically paying for expedition. So obviously the company's going to come and argue before you that it was a grease payment exception because there was nothing discretionary in it. So my question is, how would you deal with such kind of a defense? And second, since DOJ and SEC go together hand in hand, if the DOJ says that maybe they're right and SEC has a conflicting opinion about it, how do you try to bridge that gap?
I can't say that there's one answer to your question. I don't think that that type of payment would be appropriate in my personal view, but so there may well be action in terms of how given disputes between us and DOJ where we see cases differently. I think I have to answer that more broadly, and it does happen. It does happen, and from time to time, one agency will bring a case and the other agency won't, or one agency may allege something and the other agency may allege something different. I mean, we're not, there's no requirement that we always take the same positions necessarily. I think it would be awkward functionally if they were alleging this happened versus something else happened, but it's generally not that. It's more a question of, you know, this is the violation they think that can be proved, and, you know, the other agency may say, we think this is the violation, or, you know, there's always individual judgments of proof. They have a higher standard than we do. We frequently will sue more people than are criminally charged under a broader list of statutes because we have a different responsibility. They'll often focus on, you know, the worst person and the fraud. Sometimes we'll put in other people that, you know, maybe they're not going to jail, but they don't belong in the business, or, you know, there's all these other statutes that aren't quite as sexy, but we're supposed to make sure they get complied with. You know, there's a lot of things that go into it. So I think you can sometimes have differences of opinion between agencies. Yeah.
So the DOJ just announced that they're prosecuting Moody's for negligently rating certain mortgage-backed securities in '07. I was wondering what the implication will be, if any, of that holding on the SEC's activities, specifically as they relate to regulating the rating of securities.
I can't say. I mean, I can't talk about what we might do or not do, and I'm not sure. Go ahead.
Could you bring us through a typical day of a SEC staff attorney's daily responsibilities?
Yeah. The interesting thing is I'm not sure there's a typical day. The typical SEC staff attorney, and we have staff attorneys and litigators, both, and there's not quite the bright line that you would think there. The litigators help out on investigations. The staff attorneys get involved in litigation. But for a staff attorney, the typical day might be preparing an action memo, writing up a summary of a case, going through a lot of documents that they've collected in a case to kind of do their analysis, preparing to take somebody's testimony or taking their testimony. We bring a lot of people in and we take testimony from them on the record. And that takes a lot of preparation in these type of cases, because normally you have to go through very extensive documents to get ready for the testimony so you know what you're putting in front of the person. But that's how they probably spend most of their time in that context. If one of their cases goes to litigation, they will go along with it. We normally keep people with the case, so it could be they could be taking depositions, they could be helping on briefs, or as the case, if it actually goes to trial, could be spending time helping to get ready for trial and taking witnesses at trial, things like that. So it's varied, and one of the things we try to do, or I've always tried to do, is to keep people interested. We try to give people an interesting variety of cases, and most people have 2 or 3 at any one time maybe. But we try to change it. If you had one of these, have one of those, and the cases are so interesting that it's I've been there more than 30 years, never been bored, which is something, because I get bored pretty easily and never been bored.
Can you talk a little bit about your most interesting case?
My most interesting case? I've had a wide variety, and they're interesting in different ways. I mean, I thought the Morgan Keegan case that I mentioned was very interesting. It involved a lot of money, obviously, but a lot of digging into pricing violations and what was going on inside the valuation process of the fund. And it was very topical because it was after the real estate crash, and all these real estate-based investments were a big part of the problem. That was extremely interesting. The ETS case was interesting in some other ways. Obviously, it went to the Supreme Court, and I was able to go up and help prep the Solicitor General, and those kind of things are interesting. Insider trading cases, we've done a lot of them, and they tend to be interesting because they're circumstantial. Most of them are circumstantial. And, for example, you have people, you put together, you know, they got together with their friend, blah, blah, blah. The next day, the friend went out and bought, 80 million shares of whatever company the other guy was working on. And, the friend has their excuses for what they did. And, a lot of them go to trial because, they are circumstantial and there's two sides. Those are interesting. I can still remember some of the cases, like my first year when I started. When I started, Miami was like the Wild West in this area. I don't know, is anybody from Miami or South Florida? Probably somebody. But it still is, but when I started in the 80s, it was the Wild West. And there were boiler rooms, in Boca all over the place, and all kinds of offering frauds, and very interesting characters. And I had a case where, I think it was my first case, these characters were selling in investments in mineral aggregate piles, dirt piles, basically, 40 miles west of Gila Bend, Arizona. I still remember where they were. So, the early stuff sticks in your mind. And that was a lot of fun. I've had a lot of accounting cases. Some are more fun than others. And, we look at auditors too, and whether the audit, comply with rules and caught what it should have caught or didn't. And some of those can be interesting. And you have to always weigh. If you're talking about serious professionals, did they just make a mistake? Were they, reckless over the line? Were they actually complicit? Those kind of questions. So it's everywhere from Wild West scam things to very technical cases where somebody who's a serious professional screwed up something, and do we need to take action or not becomes an issue. And I guess different things are interesting at different times, but it's always been fun. I had an early case. This is which I thought was kind of cool. This was way back in the 80s, a stock manipulation case. And as I get into it, and I was from New York originally, but I noticed, hey, the company has, I'm not even going to say who they were, but a bunch of famous old Yankees were on the board of directors, and whoa, I got a case with, I never found anything wrong about it or anything. It was, renting their name, which celebrities did in those days as a director. But, that kind of stuff's kind of fun. Yeah.
So you said earlier that cases can be brought in administrative proceedings or in federal court. Who at the SEC makes the decision about where a case is going to be litigated?
Well, technically the commission, in the sense that the commission votes on the recommendations. And there's some discussion. It's not like a rubber stamp. But most of the time the decision is to recommend one or the other is made by, I would say senior enforcement management as it considers the case, and there's, reasons why they go one way or the other.
You have over 30 years experience with the SEC since 1984, and I was just wondering, have you ever considered going to the private side? Because we're all students and we're going to have to make a decision whether we're public or private.
Yeah.
After graduating, and I was just wondering if you had any advice and what was your thought process?
I kind of fell into this and just kind of fell in love with it. So, I don't know that I had a thought process. I fell into it. I was working as a state prosecutor, and I did some securities cases and thought, boy, this is really neat stuff. And then I started with the SEC, and it's just been a lot of fun ever since. And, I've lived in Atlanta, which is a relatively low cost of living city compared to like New York, and it's just always worked. And so, up to this point, I've been happy doing what I'm doing for all intents and purposes. And I have to say, there's probably a variety. Like if you, in the SEC Atlanta office, very few people leave, and I'm saying like one person leaves from enforcement every 5 years or something, if that, other than people retiring. And I think part of that is economic just the economic dynamics of it's a good paying government job in a low cost city type of thing. Probably if you go to New York, you're probably going to have a lot more turnover. So it's a complicated thing, and you know, you can go from one to the other if you want. Most of the people we hire are, you know, start in the private sector and then make a decision they want to come in. You know, it's what do you want to do? I mean, there's, you know, bureaucracy things that aren't always fun working for the government, but I think the SEC is a very good place to work. I would totally endorse going there and making a career there, but it's not the only place to work, and you know, there are certainly other jobs where you can make more money, you know.
Yeah, just to follow up on that, I know you said there's state regulators too, so if somebody wants to pursue a career in security regulation, there's SEC, state regulators, any others that come to mind?
Well, FINRA would be another one. That's a self-regulatory organization for brokers, and that's, I think it's a very big organization. I forget, you know, how many people they have, but I'm sure they hire a lot of people, but that would be a good one. There are some related entities. There's the PCAOB, which regulates auditors, and which is kind of under the SEC, but it's a private, semi-private entity. They do similar work to what we do in the auditing space. You know, I think those are the primary entities. The state regulators, obviously there's 50 of them, and so there's a lot of stuff out there. And there's U.S. attorneys' offices in most of the big cities have, you know, people who do, you know, our type of cases also. Sometimes they're specifically defined that way. Sometimes they're kind of economic crime generally, you know, sometimes not, but they do stuff, and the FBI is in the space. So, you know, there is opportunity to find your way into it. And the other thing I think is going to be interesting, it's already interesting, but in the years ahead, everything's becoming more international. Everything's tech is becoming more and more, and maybe I can just say a few words on that, because your generation is probably way ahead of where we are on that. A lot of stuff is, you know, cyber stuff is very important. I mean, obviously all the records and the trading and everything else are all computerized, and there are issues with people hacking in and doing manipulative trades or doing whatever types of violations, stealing information that they can get away with. The industry, and probably most industries, is very concerned with cybersecurity. The SEC is concerned with cybersecurity. You know, we have regulations, they're almost always phrased in terms of reasonable. You know, you have to have reasonable procedures to protect inside information and to protect your customers' identities and those type of things. But that's a constant, you know, give and take, what's reasonable, what isn't, you know. That's a big area, and you know, it's just whatever is big this year, there'll be another. It just keeps metastasizing, and you can imagine how tough it is to maintain effective regulation over this vast industry, which is online, which is around the world, and there's a lot of greed. I guess you can have greed is good, as Gordon Gekko said, but it motivates everything, but it also sometimes, you know, pushes people to go over the line. It's not going to slow down anytime soon. So it's an area that's perpetually interesting for what that's worth.
I'm just going to make a few closing statements.
All right.
Thanks a lot for your time. Everybody, could you thank Mr. Hicks for his time? Thank you very much.
Thank you.
And once again, thank you to SUPNA for organizing this activity. And thank you for the co-sponsors. Any members of ECGAR, could you sign in here once you leave? And Mr. Hicks is taking resumes. Just kidding.
No, I will make a point. I will make one more point, though. No, I'm not taking resume. We do have an intern program. And I don't know if any of you guys are in it or what, but you know, we have some people every semester, and in the summer they come and work with us. And I don't know exactly what the arrangement is with Emory, but sometimes you can get school credit, sometimes you get money, you know. But that's a way to get some hands-on
Yeah,
experience.
there's an externship